getting into my main
Your microphone, Mr. Lewis.
my main submission,
Thank you.
I should clarify that when I use the term Aboriginal fishery, I'm referring to an Aboriginal-only fishery. And the bottom line of my submission is that Aboriginal-only fisheries should be restricted to fisheries in which what is being exercised is an Aboriginal right. To the extent that Aboriginal individuals are fishing other than pursuant to an Aboriginal right, they're fishing as a member of the public. They're fishing as a recreational fisher or as a commercial fisher, and pursuant to the same rules as everyone else. And that's the importance of remembering that Aboriginal rights are additional. When we sat down, Mr. Commissioner, to look at the three questions essentially that you've been asked to deal with, and the mass of evidence and submissions that you've received, we quite frankly wondered how we were going to do it. And what we did was we came up with a number of focusing concepts, and we found those focusing concepts useful in making our way through the issues. And essentially the structure of my submission is to offer you the focusing concepts as an analytical tool, and to show you what the use of those concepts resulted in our examination of the questions, and ultimately what those focusing concepts result in terms of recommendations for the future. There are 5 concepts that we found useful. They're not new, and other parties or other participants will refer to them. The first is, and these are found at page, starting at page 5 of my submissions. The first is pragmatism. And that simply means focus on the immediate and practical as distinct from the remote and the merely theoretical. And quite frankly, Mr. Commissioner, much of the evidence, particularly the scientific evidence, is remote and theoretical. The second guiding concept is interests and values. And this means having regard to the interest or value, often hidden or obscured, which underlies the values, the evidence or positions of witnesses or participants. And by that we don't mean that the witnesses and participants have hidden agenda. Indeed, the agenda of most of the participants, or virtually all of the participants and most of the witnesses, is not hidden. And it doesn't mean, as would happen in a trial, that the function of this tribunal is to sift and discount biases. It's exactly the opposite. I will make this statement in a couple of contexts, Mr. Commissioner. This is not a trial. It is a commission of inquiry. And this is an important distinction in the treatment of the evidence, and I will go into some of the implications of that later. But here, it is the function of this tribunal, I submit, or it is useful to this tribunal, I submit, to take into account the interests and values which underlie the submissions and the evidence. In short, and to use a term that was used by my friend Ms. Gertner early in the proceedings, all worldviews are to be identified and to be taken into account. The third guiding or focusing concept is proportionality. And that means 2 things, Mr. Commissioner. First, and this is very important, it means recognizing that most, if not all, of the issues before you are issues of degree. They are relative, not absolute. They're issues of degree, how much. They are not categorical, either or. For example, what is the risk? And secondly, Mr. Commissioner, proportionality means also having due regard to the interests and values, and therefore the relative priority and importance of those interests and values. For example, what is an acceptable risk under particular circumstances? And as I indicated, paragraph 29, Mr. Commissioner, we've chosen the word proportionality rather than balance because it emphasizes the notion of judgment, of weighing, and of prioritizing in dealing with matters of degree. The fourth focusing concept is terminology. And I suggest very strongly, Mr. Commissioner, that it is important to be sensitive to the use and misuse of language. Many, if not all, of the participants and witnesses have special interests, and those interests can be obscured by the vagueness of their language. More importantly, as I say, many, if not most, of the terms and concepts used are ambiguous in the abstract and require context in order to provide specific content. Some examples, some egregious examples, are co-management, over-escapement, rights, and even conservation. You'll recall, Mr. Commissioner, that there was a special panel. One of the first panels in these proceedings was devoted to trying to debating or to giving evidence on what the word conservation meant and how it related to a term like sustainable use. And I would submit, and you'll also recall the evidence, I think it was Mr. Shamoot, who said that the wild salmon policy was essentially the DFO's definition of conservation. In other words, it defined conservation in terms of biodiversity. It separated sustainable use and conservation, defining conservation effectively as biodiversity. And I say that that's only one definition. The term conservation is an ambiguous term and needs to be used with sensitivity to the context in which it was used by witnesses or is used by participants and ultimately is used by you, Mr. Commissioner. The fifth focusing concept is dealing with the perspective, and it has two parts, and that is that the perspective is that of a public resource. I agree with Mr. Harvey's remarks this morning that the focus is to be on the Fraser River sockeye as a resource, as distinct from but not ignoring an element of nature. The appropriate perspective is not that of the species, and it's not that of Mother Nature, but the human beings which relate to both the species and Mother Nature. And I believe that Canada also made this submission and indeed referred to the same passage in the Ward case, which I set out at paragraph 31, and which, as you may recall, Mr. Shamoot agreed was effectively the perspective from which he viewed his responsibilities when he was with the department. The second part of the concept, public resource, is public. And what that really does, Mr. Commissioner, it embodies the legal principles that I identified at the outset. It's closely linked to that of resource, but it adds the legal dimension. And by public, I mean the Canadian public. And the concept has two important implications. First, as I indicated earlier, public is the antithesis of private or exclusive. And second, the public resource emphasizes the obligations as distinct from the powers of the Government of Canada, and in particular, the DFO. The Crown is a trustee of the resource. It is not the owner. And public emphasizes that. Now at paragraph 34, I set out the use of the guiding concepts, and this is what we suggest for you, Mr. Commissioner, and for your staff when looking at the evidence and the questions. As I indicated, there are three essential time periods which are to be looked at. There's the present, i.e. what is the state of the sockeye. There's the past, what is the cause of the present state of the sockeye. And there's the future, what should we do in the future. Now, in looking at the present and the past, that is in focusing on your fact-finding task, and in particular the question of causation, that we say that those focusing concepts give rise to the following guidelines. Pragmatism gives rise to the guideline, focus on the knowable and the doable. And I again remember that essentially Canada advised you or recommended the same. Proportionality plays out as look at the situations and problems as matters of degree rather than categorical. And this will have a special application when it comes to dealing with the schools of thought on causation, which I will say ultimately, Mr. Commissioner, are not mutually exclusive. And when I'll get to that. The focusing concept of interests and values results in the direction to focus on the underlying interests and values as well as the specific situations and problems. And in that way, you will take into account that this is a resource and it is a public resource, and that there are conflicting and competing interests and values that are relevant to resolution of even specific situations and problems. The focusing concept of the perspective, that is focusing on the species as a public resource, is especially important when defining the issues. As the sub-issues, the issues that need to be broken out in order to come down to the main issue. As Mr. Harvey said, you will focus, if you focus on the resource, you ask different questions than if you are focusing on the species or the ecology generally. And finally, the value or the focusing concept of terminology, I've said be clear to the point of bluntness. There's been a lot of jargon used in these proceedings, a lot of bureaucratic jargon. One got sick of hearing words like array and suite and visions and that sort of thing without really knowing what they meant. And there's been a lot of scientific jargon. And the recommendation that we have, we urge you to look through that jargon and to look at what the witnesses were really saying and what the documents really say in plain English. Now, the questions that are before you, as I indicated, Mr. Commissioner, are set out in paragraph 36 of my submissions. Mr. Harvey read you the terms of reference and put them in the formal language. In informal language, they're simply this: what is the present situation? What's the cause of the present situation? And what should be done in the future? Now, the rest of this submission addresses those three questions in light of the focusing concepts and the guidelines. Starting at page 9, I deal with the present, because that is where the terms of reference begin, and that is what what is the status. Now, I say that it's important, before looking for causes in the decline of the Fraser sockeye salmon, it's important to be specific as to what is the subject being measured and what is the metric being used. As you heard, Mr. Commissioner, that there is a distinction between the aggregate and the stocks, the components that make up that aggregate. So is the status that is being measured the status of the individual components, or is it the status of the Fraser River sockeye, which, as Mr. Walters indicated during his evidence, is a system in and of itself? The second part of that question is what is the metric? Is the metric the abundance? Is the metric the ratio of spawners to recruits, the production ratio? Those are questions that should be set out at the outset, and it should be made clear because as I set out in paragraph 41, keeping those distinctions in mind, here's the pattern that I say is the pattern that reflects the present status. And I'm thankful to Mr. Harvey for producing the book of exhibits, because the pattern that we set out in paragraph 41 is essentially, in our words, what we say the exhibits, especially the graphs of Mr. Lapointe, tell us. So he went through in detail. I will simply set out what we say those documents show. That in the aggregate, the Fraser River sockeye have experienced a severe decline in the ratio of recruits to spawners between the years 95 approximately to 2009. However, when measured in terms of abundance, the decline is from an extraordinary high level of returns, which Mr. Harvey pointed out in between around 1985 to 1990, to levels which are more consistent with historical averages. So when you look at the question of decline or describing decline, the question arises, decline from what? And what is the perspective? If you go back in the graph to the 40s and look forward, you'll see that there hasn't been a severe decline. If you go into the mid 80s to 90s, where you're at the top of the peak of the returns, of course, it's a drastic decline. So are you measuring a decline in historical terms, or are you measuring a decline from that top of the peak? So as I say, in terms of abundance, it's from an extraordinary high level to a level that is low, but stepping back is not inconsistent with historical averages. I say that the drastic decline in both, that is in abundance and in the ratio of recruits to spawners, is driven by the decline in the larger stocks. That most of the stocks, particularly most of the smaller stocks, are relatively stable and healthy, and that the most serious problems are stock specific and identifiable. And I won't go into it, but in the following paragraphs, I set out, Mr. Commissioner, where you can look to find out the best evidence on the status of those individual stocks, and they're essentially Slaney and Dr. Walters in his slideshow, Where Have All the Sockeye Gone? Unfortunately, we don't have an equivalent analysis using the new units, the conservation units, and so the analysis will have to be made in terms of the traditional stocks and or the aggregate. Now, at starting at paragraph 47, I set out what we say the pattern is, shown by the evidence, and in particular the evidence referred to by Mr. Harvey this morning. What is the decline that we're talking about? We say there are two declines before the Commission. There's a long-term decline and the precipitous collapse in 2009. And by long-term decline, I set out in paragraph 48, and there's an error here, Mr. Commissioner. I say that the description is a 4-year cycle average. It's in fact a description of the history of the 2009 cycle year decline. By 1993, the aggregate stocks on that cycle year were built from a low following the Hell's Gate slide to approximately 23 million. From 94 to 2008, they declined to the order of 2 million. And that decline was in stages, from 23 million in 93 to 16 million in 97, roughly, to 7 million in 2001, approximately, to 7 million in 2005, approximately, and to virtually zero in 2009, or 2 million. By short-term collapse, we refer to the facts that in 2009, the escapement was just over 1 million, which is less than 1/2 of the average cycle escapement and approximately 1/3 of the escapement in the previous cycle year. And here's the important factor that was drawn to your attention by Mr. Harvey, that this decline took place during a period in which the commercial harvesting rate had dropped from an average rate of 80% between 1950 and 1990 to firstly approximately 40% in the mid-90s to the mid-2000s, and then essentially zero from 2006. Notwithstanding that, escapement had increased by approximately a factor of 3 from mid-1950 levels from 1990 to the mid-2000s. In terms of recruits per spawner, I set that out at paragraph 51, and as Mr. Harvey indicated, they have fluctuated, and between 1992 and 2009, it dropped to barely 1 recruit per spawner on an aggregate basis. Now, and I'm at page 57 here, Mr. Commissioner. This decline didn't occur in a policy or political vacuum. Over the critical period, there were important and significant changes in both management mechanics and policies that were not driven at all, or not solely driven by biological or environmental concerns. The measures were proactive rather than reactive, and they include these: the 1987 rebuilding program, the Aboriginal fishing strategy, the redesign of the commercial fishery for economic efficiency through the Mifflin and Anderson plans, the expanding mandate of DFO. You'll recall, I think it was Ms. Dandero who used the term mandate creep, and the shift in responsibility for setting escapement goals from the Pacific Salmon Commission to DFO. A further significant change, Mr. Commissioner, was that to weakest stock management. And although that policy cannot be completely delinked from conservation issues, it does share the characteristics of being proactive and aggressive rather than reactive and incremental with the other changes. pages 59 through 64, I set out what I say are the implications of those changes, and given the time constraints, I won't go into them now. I would point out, however, at paragraph 63, when we talk about the range of objectives and consequent policies, Mr. Commissioner, you will probably recall a number of occasions when you asked witnesses from the Department of Fisheries and Oceans about the hierarchy of policies and visions and discussion papers and that sort of thing, and also what you were to do with the fact that so many of them were described as works in progress. And that is part of the context in which this decline takes place. One asks, how can those policies and those programs be related to one another, be coordinated, be implemented, be assessed, and be modified when they're works in progress, and one does not necessarily flow from, one new does not necessarily flow from the completion of the former one. I want to quickly, but in some depth, go to the question of the evidence on causation. And my bottom line there, Mr. Commissioner, is this. You've heard from what I categorize as two schools of thought. There's the population dynamics school of thought, and there's the environmental effects school of thought. And those schools of thought have come up with different hypotheses, and they've come up with pointing to different evidence in support of those hypotheses. When push comes to shove, I agree with Mr. Harvey's submission that the evidence dealing with and the hypothesis with respect to the population dynamics school is preferable for a number of reasons, which I will outline in a minute, to the evidence from the other school. But I do have some remarks to make which are not in my written submission about my suggestions about how the Commission should treat the evidence in those two schools of thought. It's not necessary to decide between these approaches. This is not an either-or issue for the Commission for a number of reasons. First of all, as I indicated earlier, this is not a trial. You are not called upon to resolve a dispute between interested parties, let alone a debate between scientists. You're charged with the responsibility of finding out the facts, of determining where the truth lies. And the truth may have multiple layers. Secondly, the objectives of the two approaches are substantially different. The objective, if I understand it, of all of the scientists is to find correlations between variables, to find a y which is a function of an x. In the population dynamics school, the x is the number of spawners, and the y is the ratio of recruits to spawners. In the environmental effects school, the x is something else, we don't know what, and the y is the ratio of recruits to spawners. They're looking for correlations. The level of analysis is different. This is why you don't have to choose between them. In the population dynamics school, as I understand it, the existence of the correlation is itself significant. As the number of spawners goes up, the ratio of spawners to recruits or recruits to spawners goes down. It doesn't matter why. It's just that the correlation is there, It's been shown to be there. It's embodied in the Ricker and Larkin curve. And Mr. Walters, to personify that school, Dr. Walters, to personify that school, simply says, there's the correlation. We don't have to understand why it works to know that it works. It's like understanding an algebraic equation. You don't have to give a value to the x to watch the function of the y and the x. You don't have to understand the content of the quanta to watch the quanta in the behavior of the quanta in quantum physics. It's like a bracket. It's like a bracket. You don't have to know what's in the bracket. The different levels of analysis. The stages of verifiability and development are different. The Ricker and Larkin models are verified and used by fisheries managers and biologists. With respect to the alternative, the environmental effects, there's no specific correlation postulated, let alone verified, let alone used. At the end of the day, and again, if I can personify it, Dr. Peterman and Dr. Memerick say there's something at work, probably, other than or in addition to population dynamics, but we don't know what it is. As I will indicate in a minute in a little more detail, the two approaches are not mutually exclusive. There doesn't have to be one cause. There can be multiple causes. There can be different causes between different stocks. And again, as I indicated, Mr. Commissioner, these are matters of degree. It's not an either-or choice. You don't have to choose between Walters and Peterman. And lastly, and I think this is the most important point, the population dynamics approach applies by definition to large stocks. The large stocks are the important stocks economically and biologically. They drive the system. And even if the population dynamics approach only explained the decline in one stock, the quenelle, and it doesn't, I say that it is a probable cause of the decline in most of the long stock. But even if it explained the decline only in one stock, if that stock is significant from both a biological and a social and economic point of view, that is a matter of urgency to the Commission. Having said those, why you need not choose between the two schools of thought, Mr. Commissioner, I'd like to turn to paragraph 68 and indicate why I prefer in the context of this Commission, the population dynamics school. I say, firstly, it provides a clear and supportable hypothesis for the cause of the long-term decline. Secondly, it provides an explanation both for the collapse in 2009 and the large return in 2010, and Mr. Harvey took you through that explanation. Thirdly, it does not require the identification of the specific causal factor. As I indicated, you don't have to know why the ratio goes down when the population goes up. You just have to know that it does. You don't have to know why. You don't have to know where. You don't have to know whether the effects are in the lake, the river, or the ocean. Or you don't have to know when in the life cycle it operates, or whether it depends on single or multiple environmental factors. It's there, it's tried and true, it's in the Larkin and Ricker models. And I think perhaps most importantly, it provides a practical means of testing the hypothesis and if supported, taking remedial steps. The remedial steps being, of course, dealing with exploitation rates. Now I say in paragraph 69 that, while not to be ignored, the environmental approach in the main, as we've seen in these proceedings, does not have the same clarity in terms of hypothesis, does not account for the collapse in 2009 and the large return in 2010, requires the identification of a specific factor or factors. In fact, that's the object of the exercise. And finally, if proven, offers no apparent short-term remedy other than ever diminishing fisheries. And that's where we are if the population dynamics school is ignored or rejected. I don't have the time, Mr. Commissioner, to go into the evidence and the detail. It's in my written submission about the difference between the two schools of thought. Perhaps I'll just take you quickly to paragraph 94, where I say this. The evidence shows that density-dependent effects are a likely cause of the decline in production of some stocks, and that these stocks are the major components of the Fraser River sockeye. The possibility or even probability that other factors are at play in other stocks, or even the same stocks, does not diminish the importance and urgency of attending to the impacts of over-escapement. I'll skip very quickly. I think I have a few minutes left, just to highlight how the focusing concepts play out into the future. That is the recommendations, and I'll be at page 23 of the submission, and these really are recommendations that are directed at the Department of Fisheries and Oceans. Pragmatism plays out as the direction to be conservative in the approach to changes in fisheries management. We've heard a number of witnesses talk about uncertainty and the need for transformative remedies. At paragraph 110, I deal with that. The second direction given by the focusing concept of pragmatism is attend to the known stock-specific problems. And there are three: the early Stuart, the early migrating late sockeye, and the cultus. And thirdly, apply the principles of adaptive management, which are all found in Dr. Walter's textbook referred to by Mr. Harvey this morning. Proportionality manifests as look to the costs as well as the benefits of management decisions. Balance, strike the appropriate balance between management and science, and strike the balance between science and experience, both personal and institutional. Perspective, I've really dealt with that. The point is that the fisheries resource, or the fishery, is a public resource. The question on the interest of terminology, or the governing concept of terminology, really comes down at the end to a plea for transparency. A plea for transparency from the Department of Fisheries and Oceans as to what they're doing and why they're doing it. And in particular, transparency about the Aboriginal agenda. Are we talking about fishing issues that relate to Aboriginal people, or are we talking about Aboriginal issues that relate to fishing? Because they're two different things. What is driving the agenda with respect to Aboriginal fisheries and the relationship between those fisheries and the public fishery? I see that I'm out of time, Mr. Commissioner. I wish you well, and I hope that our focusing concepts help you in your endeavor.
Thank you very much, Mr. Lewis.
Mr. Commissioner, John Galis, here today on behalf of the Western Central Coast Salish First Nations. And with me here today is Robert Clifford, who's an article student, helped us out on the written submissions, which I don't intend to refer to in any detail. I just want to make note, however, that you'll see on the first page there, this was quite a collaborative effort. Ms. Leah DeForest, David Robbins, Holly Veer, Robert Janes, and Sarah Sharp. We worked together on these submissions and managed to pull them together. They're quite comprehensive submissions, Mr. Commissioner, and we look forward to you reviewing them. Just by way of background, again, for the record, Mr. Commissioner, when we speak of the Western Central Coast Salish First Nations, we're talking about 9 First Nations: Cowichan, Chemainus, Penelakut, Paleedsum, and the members of the Timucua Treaty Association: Songhees, Manus, Beecher Bay, Sook, and Malahat. My clients have asked me to thank you, Mr. Commissioner, for granting them standing in this commission and giving them the opportunity to participate. We'd also echo the comments of council as to the thanks for the commission council and the staff and the degree of professionalism and hard work. For the next day and a half, Mr. Commissioner, you're going to be hearing from a number of First Nations participants. I have the privilege to bat leadoff for the First Nations. So I need to talk a little bit about the law. We're going to briefly discuss causes and DFO priorities, and then the main part of our submissions are going to be on the Aboriginal issues. So we've got some submissions, Mr. Commissioner, reply to BC and Canada, and I guess to a certain extent Mr. Lowe's has nicely teed this up for us. We submit, Mr. Commissioner, Canada and British Columbia's submissions are illustrative of the impoverished view of Aboriginal and treaty rights. There's 3 areas in particular that require comment: the Aboriginal Rights Framework, the Aboriginal right to fish for what's commonly been known as FSC purposes, and Canada's approach to Douglas treaties. Now, BC at page 18 of its main submission says this: the Commissioner is not required to, nor should he, make findings with respect to the state of the law concerning Aboriginal rights and title to fisheries given the evolving state of the law. We submit that, Mr. Commissioner, your recommendations must be cognizant of and consistent with the Section 35 jurisprudence. We provided a legal framework in our submissions that we say must guide you in making your recommendations. You also want to take a look at PPR number 1, our written submissions in reply to that, as well as some of the, all of the, I would say, First Nations submissions in that regard. At paragraph 10, it's at page 2 of our final submission. I wanted to summarize this, but I don't think I could put it any better than this, Mr. Commissioner. We say, the Commission must also have regard to these rights in formulating its recommendations. The Commission's recommendations are only useful to the extent that they can be lawfully implemented. As such, these recommendations must be consistent with the existing Aboriginal and treaty rights of all affected Aboriginal peoples in accordance with the fashion that those rights are protected by Section 35 of the Constitution Act. This means regard must be had both to the substantive aspects of Aboriginal and treaty rights, i.e. the Aboriginal right to fish, as well as the rules limiting the extent to which the government can interfere with these rights. And I'd also add to this the right of consultation that comes from that. Now, BC goes on at paragraph 4 of its reply and says, consideration of Aboriginal right to fish should not include making any specific rulings or findings with respect to the scope of Aboriginal title or the Aboriginal right to fish, or with respect to the treaty right to fish. Now, Mr. Commissioner, you're not going to be expected to make any specific rulings on the Aboriginal title or Aboriginal rights of the participants in this inquiry. But I think we should take a look at what Dr. Harris has had to say in his testimony of June 27th. It's at page 90 of the transcript. So at line 7, it's actually Mr. Dixon doing some cross-examination. He says, and then you say in this first paragraph on this page further, fish were crucially important as food in many Aboriginal societies in North America, but also facilitated the accumulation of wealth. And then he goes on to say, I'm interested in the last portion. Dr. Harris at line 19 replies, he says, so fish, and salmon in particular, were the single most important, or was the single most important resource in the territory for Aboriginal peoples. And this territory supported as large and as dense a pre-industrial, non-agrarian population as existed anywhere in the world. There was a remarkably dense, sophisticated political society here that was built around the fishery. A society that included a social hierarchy with nobility at the top and slaves at the bottom. A hierarchy that allowed for an enormous cultural production. A society, rather, that allowed for enormous cultural production. All of this was made possible because Aboriginal people and the cultures that they built were specialists in the catching and processing of fish. Mr. Commissioner, to sum up Dr. Harris's testimony, and we address this also in our written submissions, salmon was the centerpiece of the society, and it continues to be so. There was a sophisticated, organized society whose sustenance, culture, and economy was built around the fishery. This isn't a matter that's in dispute, Mr. Commissioner. The historical and anthropological evidence on this is overwhelming. In Sparrow, the court opined and said the existence of the right was not a subject of serious dispute. I submit, Mr. Commissioner, certainly when it comes to fishing for food, social and ceremonial purposes, there should be no dispute that each of the First Nation participants in this inquiry, as well as the other First Nations along the migratory route, has an Aboriginal right to fish for FSC purposes. Although some of Dr. Harris's evidence may be controversial, the historical record is not. First Nations have fished since time immemorial for food, social, and ceremonial purposes. Now, this fact is implicitly recognized by DFO throughout its policy and its operational decisions. We have licensing, we have openings, we have the priority that's given to Aboriginal fishing. I submit this may explain why DFO does not comply with the HIDA consultation framework. There's no need to do a strength of claim if the right exists. Finally, I'll just wrap up here, Mr. Commissioner. There is a dispute, we agree, whether the Aboriginal right to fish includes a right to sail or even a moderate livelihood. However, the right is not simply the right to dip a net in the water and come up empty. Now, I didn't come up with that. That comes from a judgment of Mr. Justice Orrick in the U.S. and Washington case, 1980, what's often referred to as Bolt. And that's found in paragraph 159 of our submissions. I note the time, Mr. Commissioner.
Thank you very much.
The hearing is adjourned until 2 p.m.